Contracts can end through any of the following ways. Performance. So in this case, you've done your part of the contract. Well, the contract is over, right? Agreement. Well, it's simple. If the contract was made by an agreement, then it can obviously be discharged by an agreement. We're talking about things like release, new agreement, accord and satisfaction, or even a provision that just contains how you're going to discharge that contract by agreement. It can also end by frustration, talking about events occurring in a contract that makes it impossible to continue, or breach of a contract that can also terminate a contract, or operation of the law. Now, in this video and series of videos to follow, we are interested in what happens if a contract has been breached. Now, if you're new here, just point out that you should subscribe and hit that notification bell to be notified each time we put a new video. And so in this channel, we are all about education. So we'll be doing videos on business, law, finance, development, all that stuff. So make sure you subscribe. The one thing that you really need to understand is that people don't intentionally get into contracts with an aim of breaching it, unless they are that kind of a person, okay? The kind of a person who doesn't just keep their words. But for the most part, people get into contracts because they expect something out of it. But then sometimes breaching just happens, or, well, they could do it intentionally, but that's not necessarily why they were in that contract. A party to a contract may commit breach of that contract by repudiating his liability under the contract before the time for performance is done, by his own act or disabling himself from performing the contract, or by failing to fulfill his obligation when purporting to perform the contract. So what happens when a contract is breached? Well, later in this video, you'll see that what happens when a contract is breached will depend on the type of breach, okay? And for the most part, it will depend on the term of contract that has been breached. We're talking about, is it a strong term or is it a weak term? Well, regardless of the strength of the term of the contract, if the matter goes to court, the court will always look at the following things in relation to figuring out whether there was a breach or not. Number one, that a contract for specific purpose was put in place. Number two, that a term in the contract was broken. Okay, first of all, if you are really struggling with terms of a contract, there's a link in the video description to one of my contract law classes, okay? It's a basic introduction to contract law where you can learn about formation, terms, all this stuff. So just click, check it out. Link is in the description. Now, number three, that losses were incurred or expected to be incurred as a result. And number four, that the other party involved in the contract was responsible for the losses. Here's how all that works in practice. So let's say you're running a business, you're selling juice, okay? So you're running a juice parlor business. And so you contract with another guy whose job is to supply you with oranges. So if they fail to supply you with oranges, it means you don't get to make the juice, which means you don't get to sell anything, which means you get to incur a loss. So if you look at the questions that we talked about, it's going to be something like this. Number one, did a valid contract exist between the two of you? Was a term in the contract breached? In this case, the term is going to be delivery, okay? Number three, were losses incurred? And number four, is the other party responsible for the loss? So holding all factors constant, you're going to say the orange supplier, okay, is responsible for the loss because they didn't supply you oranges and all that stuff. So you see how that one works out. Now, other sources of a breach of contract will include breach of confidentiality. We're talking about some sensible information, okay? That can be a source of breach in that contract. Negligence can also be something else in the contract. And with negligence in contracts, it could lead to product liability. If you're having a problem, again, what is product liability and how does it work? Again, just check the link in the video description. You're going to see a link to one of my product liability courses. So let's move on. How does breach of a contract relate to contractual terms? Well, when most people hear about breach of a contract, then they automatically assume that it's time to sue and make a lot of money. But that's not always a good idea. It's not always a good idea to have litigation as your first solution to any problem you have when you're contracting. I mean, the entire basis of this course, managing contractual risk, is that you really need to have other ways, okay, of mitigating the losses or managing the risks that could occur in a contract that don't necessarily mean running straight to the court. And even if you go to the court, you really need to go there knowing what you're going to sue for. Okay? So, failure to meet a contractual term can be a breach, but they don't all call for lawsuits. For example, ordering 10 pieces of something, okay, and getting 12. So you wanted 10 pieces of, I don't know, you wanted 10 oranges, and the supplier brought 12, and you paid for 10. And so in this case, you know what has happened? The suppliers breached the contract, okay? They failed to meet a description that you gave them. The question is, are you going to sue them? Now, the reverse can also happen, okay? You could order 10 and they supply 8. Are you going to sue them? Now, notice, both are just the same thing. In both cases, they've failed to meet a description. They've breached a contract, okay? Because you described something, you wanted 10, they supplied 12. You wanted 10, they supplied 8. So, both are conflict. It's just a question of how you're going to handle it. If you're going to understand the effect of breach of a contract, start by understanding the term you're dealing with, okay? Is it a condition? Is it a warranty? Or is it innominate term? Here's what I mean by that. Now let's start with the first one. What is a condition? A condition is a strong term in a contract, okay? It's the kind of term that if you breach it, the contract is off. For instance, if you want a car and you actually want a Mercedes-Benz, then you can't supply your BMW because in that case, the brand was a condition. But then it's not necessarily the case that if you want, anyway, just think of it that way, okay? A condition is something that if it's not done in that contract, the contract is off. It's a strong term. A warranty, number 2, is a weak term in a contract. So warranties don't necessarily terminate contracts, but they can lead to lawsuits which call for damages. So let's go back to your Mercedes example. You want a Mercedes. They supply a Mercedes, okay? Whatever make that is. But then you wanted the tires to be of a certain type, okay? Which means something to you. And then they supply them with, the dealer gets you the car, but with different types of tires. Now, you may not really call off the entire contract because of the tires. You probably just tell them to change the tires, but you still keep the car. So in that case, the tires were not a condition, they were a warranty. So, terms of a contract, okay? Condition, strong term. Warranty, weak term. You breach a condition, the contract is off. You breach a warranty, the contract is still on, but you get to pay damages. Innominate terms, on the other hand, are, well, these are weird terms, okay? It's kind of a term that is between a condition or a warranty. The thing about innominate term is that its effect in a contract will depend on how the parties perceived it. Do you perceive that term as a condition, or do you perceive it as a warranty? What does all this mean? The point of all this is to let you know that when it comes to contracts, okay? When it comes to breach of contracts, the whole idea of condition, warranty, innominate terms, we always have to take the context into account. So if a supplier supplies you with something, let's say t-shirt, okay? Or let's say a pen. So when they supply with their pen, what do you want a pen to do? You want a pen to write. So if the pen doesn't write, then that pen is not fit for purpose intended. So that means they failed to meet a condition. On the other hand, if the supplier who's supposed to bring you these pens said that, okay, you wanted them to bring you the pens in the morning because that's the time that you'll be in the office. And then they call you and say, we are going to be late. So then they end up bringing the pens in the afternoon. Now, assuming the pen doesn't necessarily affect anything that you're doing in that business, then the time wasn't really a condition, okay? It was a warranty. So the point is, you always have to take all factors into account in order for you to decide if something is a condition or a warranty in some contracts. Because in some contracts, it's fairly cut and dry. I mean, you look at it, you know that's a condition. You look at it, you know that's a warranty. Now, in order to figure out if you've understood that or not, let's try this example, okay? So here's a question that I want you to try and give an answer to. Say whether the following are condition, warranty, or innominate term. Number 1, a contract is made for the sale of goods which state that the shipment needs to be in good condition. Number 2, a decorator is contracted to paint a hall in a school in a specific shade of blue. Due to problems with availability of the paint, he paints the hall in a slightly darker shade of blue. Number 3, a country's National Defense Department places an order for 3 submarines. On delivery, it is found that the submarines are unsafe to submerge in water safely. So, what are we talking about? Okay, tell me, is it a condition? Is it a warranty? Is it nominate terms? Those three. So yeah, remember, breach of contract simply means failing to meet certain terms in a contract. And the effect will depend on whether it's a condition, it's a warranty, or it's an innominate term. So let's move on to something else. Try to answer that question. Now let's move on to something else. Let's talk about affirmation of a contract in case of a breach. So if you choose to affirm a contract, what exactly does that mean? Well, that means that as an innocent party, you are aware of the two options available to you and that you are in fact choosing to affirm the contract. Here's what I mean. Let's say you hire a cleaning company to clean your office, and part of the terms in that contract is that they should not use cleaning products that contain certain chemicals. Except they go ahead and they use cleaning products that contain those particular chemicals that you didn't want them to use. Now, it cannot be said that you affirmed the contract if you are not aware of such. Hence, the consequence of such lies with the contractor. So remember that when it comes to contracts, things can be expressed or things can be implied. Your actions, for instance, are implied, and therefore your actions can be read as though they affirmed the contract. So, to avoid risks, it's a good idea to have affirmation in writing because of the misunderstanding that can later occur. Note, once the innocent party is seen to have affirmed the contract, it is irrevocable and cannot be undone. So in the next series of videos, okay, we are going to look at the effect of all these breaches of contract, okay? Major breach, minor breach, fundamental breach, anticipatory breach. This video is just an overview into breach of contracts and what that could mean to you. So I'll see you in the next video.